Amendment number 2 is dealing with the Redevelopment Powers Act. Specifically, under the Redevelopment Powers Act, there's this tool that we've used for several years now in Georgia called Tax Allocation Districts. Probably the most famous tax allocation district project in our state has been Atlantic Station. Y'all familiar with Atlantic Station in downtown? That was a brownfield site. It was an old steel mill that they redeveloped. The idea here with tax allocation districts has been there's areas that are blighted, that have environmental contamination, that developers won't touch. It's just too costly to go in and redevelop those areas. So somebody has to go in and bring them up to a level where they can be redeveloped. And since the developers aren't going to do that, those areas will sit for long periods of time in their blighted state and never get redeveloped. So this was a tool that was designed, and it's been used in many other states. In other states they call it tax increment financing. You may have heard that term. The idea is what you do is you issue bonds, you take the proceeds from those bonds, and you build the public infrastructure necessary to build that area up. You fix any environmental problems, such as environmental contamination and that kind of thing. You bring it up to a state where a developer will want to come in and do a project. Now, to pay back those bonds, the city council, if it's in a city, county commissioner, and your school boards have to make a decision whether to include their tax increment. So they would have to decide whether they would pitch in some of their future property tax revenues to help pay back those bonds. So the way it would work, let's take Atlantic Station as an example. The value of Atlantic Station before it was redeveloped was, say, $7 million. So the property taxes that they paid to the county, city, and school were based on a $7 million value. Once they redeveloped that property, it's $500-something million in value now. They still pay taxes directly to the county, city, and school at the same level before it was redeveloped. But all that tax coming off the new value is going to pay back the bonds until they're paid off. Once the bonds are paid off, all that money then will revert back to the county, cities, and schools. Now, immediately, there's obviously some other revenue benefits that all three of those local jurisdictions receive. The surrounding values around Atlantic Station obviously also went up in value because of that project, and they were able to capture those new revenues immediately. Sales taxes are obviously generated off that development, and they're able to capture those revenues immediately. So the only revenues that they're deferring until the bonds are paid off are the tax increment on the properties within the tax allocation district. Now, getting back to Constitutional Amendment number 2. The need for this constitutional amendment came about because of a Supreme Court decision during February of this year. The Supreme Court said there's actually a gentleman in Atlanta that was opposed to the Beltline project. Most of y'all probably heard of the Beltline project. And he filed suit, and it went all the way to the Supreme Court of Georgia. And what he argued was that our current Constitution does not authorize the school board to contribute their tax increment into these districts. And the Supreme Court ruled in his favor and said, yes, there is no authorization currently in our Constitution that would allow the school board to make that decision. So what this constitutional amendment would do is basically would put it back to how they were operating prior to the Supreme Court decision, and it would allow school boards to make the decision on a project-by-project basis whether to include their tax increment into these redevelopment projects. I'm going to stop right there. I'm going to ask Sonia Masti. She's with the Atlanta Development Authority, and she's specifically been working on this amendment, and I'm going to let her add to the discussion, and then we'll open it up for questions.
Thanks, Clint, and thanks everyone for coming out. My name's Sonia Masti, and today I'm representing Georgians for Community Redevelopment. I'm going to quickly read how the ballot is stated. The ballot language says, to authorize local school districts to use tax funds for community redevelopment purposes. Pretty simple, but it is actually a complicated issue. Let me start by saying that Amendment 2 is about preserving an economic development tool that has the ability to bring jobs to communities throughout Georgia. This is a tool that cities can choose to use or not, or they could choose not to use it. It's nothing that they have to do, and in fact, this has been used in Georgia for many years, and it's been used around the country. It's a best practice economic development tool throughout the United States. The tool, like Clint said, it's called Tax Allocation Districts, or it's called TIFs in other states. And what a TAD is, it's the 3 taxing jurisdictions, a county, a city, and a school board, will come together and they'll say, okay, there's a particular geographic area in their city that nothing is happening. It could be blighted. There could be environmental contamination on the site. There could be topography issues. For whatever reason, there are hurdles to a particular geography, and the community is not happy with the status quo. They want to make a change. They want something to happen in a particular area. They want investment. They want new development. They want vibrancy. They want to reduce crime, things like that. So the 3 taxing jurisdictions will come together and they'll say, okay, we are going to go ahead and, in essence, freeze the tax base. And all 3 jurisdictions will continue to receive all the tax revenues that they have been receiving. And it's only the new incremental tax revenue from the new development that wouldn't occur had it not been for the TAD in the first place. So it's those new tax revenues that will then go towards repaying the bonds that and during bond issue, it's that initial capital infusion that helps to build the infrastructure and make the whole thing possible. So that's kind of in a nutshell how TADs work. And once these bonds are paid off, which could be, depending on the terms of the bonds, 15, 25, or 30 years, those tax revenues then revert back to all 3 taxing jurisdictions. And in essence, especially school boards, because they account for 50% of property tax revenue in a lot of cases, those taxing jurisdictions, once the bonds are paid off, in essence receive almost like a windfall. They get just a huge infusion of revenue once those bonds are paid off. Local governments use TADs to drive economic development by attracting private investment to areas that have been ignored in the marketplace for decades. By helping local governments attract redevelopment and leverage private investment with gap financing, the use of TADs result in new jobs, decreased crime, new customers, and improved economic vitality. More than 50 cities around Georgia have approved the use of TADs, and more than 20 of those communities have actually created TADs and are at varying stages of development currently. So there are TADs throughout the state, and there are projects that are underway, and because of the Supreme Court ruling in February, their incentive in essence got cut in half. And so now they are all in a holding pattern around the state. These projects are not sure if they can move forward because there might not be enough money. These TADs provide gap financing, and there may not be enough money to make these deals viable without the school increment part. So there's a lot of communities around the state kind of holding and hoping that this amendment passes so that these projects can go forward. Amendment 2 does not require school districts to participate. This is actually a very important point. When all 3 jurisdictions are deciding whether they should participate in a tax allocation district, the school districts have the choice to opt out. If they don't want to participate, they don't have to. And there's an actual example in the city of Atlanta. There's the Princeton Lakes TAD that was created a few years ago. And in this particular tax allocation district, they were going to be building a lot of single-family homes. In most of the other TADs, at least in the city of Atlanta, they're urban TADs with a lot of commercial mixed use and condos, kind of TADs that are not going to attract a lot of school-aged children. But in this particular TAD, in the Princeton Lakes TAD, they were going to be building a lot of single-family schools. And the school district looked at that and they said, you know what, there's going to be a lot of children moving into those homes, and they are going to need that future incremental tax revenue to educate those children. And in that particular case, the school board opted not to participate in the TAD. And that TAD moved forward with only the county and the city tax increment. The rest of the TADs, at least in the city of Atlanta, the school board does participate because most of the TADs don't attract a lot of children, and the school board is not going to need those monies to educate children in the future. So that's just an important point that school districts, it's an option for them to participate in TADs if they so choose. And school systems do not lose any existing funding for education as a result of agreeing to participate in a TAD. So, you know, they still continue to get the money that they were receiving, and it's only that incremental tax revenue that goes towards paying the bonds. But the current education of kids is not affected. So if anybody has any questions.
Let me mention there's one other feature that is authorized under the tax allocation districts that schools can utilize. If you've got a school system that sees that the project's a good project, but it does have a residential component to it, and it will put some kids in the school system, they have the option, instead of just not participating, to participate but do a payment in lieu of tax, and that would be negotiated on the front end. So they could say, you know, we estimate that this project's going to put X number of kids in our school system for the next 30 years while we're paying off these bonds, to make sure that we have money to provide the services to those students over that period of time. We're going to charge a payment in lieu of tax of X amount. So again, it may not be as much as the property taxes they're losing, but they could generate some revenue using that payment in lieu of tax feature. Any questions?
Are you ready?
Yes.
Ms. Mosty and Mr. Mueller, first of all, I want to thank you for coming down. I'm State Representative Steve Davis. I represent this community here. I've been openly opposed to this constitutional amendment for several reasons, and I wanted to ask you a couple of questions and your thoughts on it. First of all, the handout that you have here, and it talks a lot about blight and in brownfields and, you know, economic or ecological repair, but isn't it true that the amendment allows them to do these tax allocation districts anywhere for any purpose, as long as they could be strictly for an economic development tool and have nothing to do with a blighted area? And their current TADs in operation now in locations where the home values are in excess of $500,000.
There has to be some hurdle to development. The definition of blight does not have to be met, but there has to be some hurdle, whether it's environmental contamination or there could be a topography issue. Maybe the site has a lot of rock or something like that, but there has to be some hurdle to that area that has been pushing development away for whatever reason.
I don't know of any specific cases where there wasn't some impediment to development. I know that some people talk about what happened in Marietta, because Marietta's done several of these. In those cases, many times they were trying to take old housing projects and tear them down and redevelop those areas. I will tell you, a few years ago there was a legislator that wanted to use TADs to do some development along the 316 corridor going to Athens, and he wasn't able to do it because of the law. And it would have been like what you were suggesting. It would have really just been development. There really was nothing. There was an impediment there. In other words, there wasn't any barriers, I guess, that would cause a developer to not go there because they couldn't develop there just like they could develop anywhere else, starting from the same playing field. But there is a definition in law. I will tell you that people argue over that definition just like any other definitions in state law. So it is subject to legal interpretation. Ultimately, the courts, I guess, would have to decide. It's like anything else. Anything in state law can be ignored or abused. And I'm not saying that somebody couldn't abuse TADs or couldn't interpret a very broad definition of how it could be used and misuse it. But in those cases, somebody would have to file a complaint, and the courts would ultimately have to make that decision, did it fall within that definition in the law?
Well, I appreciate that answer, and I understand that, and that's one of the reasons we have the constitutional amendment in front of us, is because the original law from 20 years ago was actually unconstitutional. So the one other thing that I really wanted to talk about was the economic side of it. With the economic situation that's going on in our country and our state right now, what happens if the property values don't meet the estimates in the bond package, and there's a buyback or a default, or a developer goes bankrupt? Who and where would the funds come to make up for the bonds that were sold on the front end of the development?
Yeah, I can answer that. In the city of Atlanta, taxpayers are not on the hook. The city does not back the bonds with its good faith and credit. Those bonds are sold on the open market, and the bondholder, they're paid back strictly with the incremental tax revenue, whatever that may be. So it's the bondholder. And this is in the city of Atlanta. Different areas around the state, depending on their ability to sell the bonds, they may decide to back the bonds. But in the city of Atlanta, the city does not back the bonds and is not backing it with their credit, and taxpayers are not on the hook.
Well, and the reason I ask that is in the same reason that we have the amendment, because someone actually challenged it for the first time. Isn't it true that if these local taxing jurisdictions are collecting the tax for the tax increment financing for the district, that they are by fault going to be liable to pay back the bonds that were originally offered, whether or not they did it through a referendum of the board or not? If they're collecting tax to pay off a debt, that they will be liable and the taxpayers will be on the hook. And that was part of the argument in the debate that went on downtown when that came through. Another concern I had was the housing part of it. And you talked about the payment in lieu of. You know, in the suburb, you know, we have an abundance of housing, and we need some commercial base, and there's always economic and infrastructure needs. But how is this going to interact with the regional governments dealing with developments of regional impact and the DRIs forcing affordable housing in suburbs that really do not need affordable housing?
This is strictly a financing tool. The DRI process would apply whether the development was occurring within a tax allocation district or outside tax allocation district if it meets the criteria of a regional project. And I don't disagree with you that there's some problems with the DRI process. The DRI process, though, it's not binding. It's something that developers, when they have a sizable project that has a regional impact, they have to go through it by state law. But the recommendations that come out of that process then go to your city council or your county commission, and they have to, as your elected representatives, have to make a decision on whether they change some of the requirements before that development can move forward or not. So it is strictly a recommendation to the governing authority that has the planning and land use and zoning controls, and then they have to decide how they will use that information. But as far as the tax allocation district, it will apply inside or out. The TAD itself doesn't have any direct impact on the DRI. The DRI process will be done whether it's in a TAD or not if it qualifies. On your other question real quick, on the bond financing, it works a lot like, obviously there's a lot of developers going bankrupt right now, and somebody gave them a loan. In those cases, many times it's a local bank, and those banks then they were the investors. They're the ones that are having to make up for the loss. In these TAD bonds, you've got larger investors, institutional investors, that invest in them. They price the bonds fairly conservatively. The way they price these bonds is they base it on no inflationary growth in the district. In other words, they say, okay, once we build these projects, what are they worth? But we're not going to project what those projects may go up in value over the 30-year period of time those bonds are being paid off. So they're priced pretty conservatively. Yes, you could have a situation where your timing is really bad, and the project, right in the middle of the project, we have what we're having right now in the economy, and it doesn't get finished or may delay it. In those cases, the bonds, it may take longer to repay them. Because if you don't have as much revenue, then you extend the period of time it takes to repay them. But I don't know of any case where the local government would be on the hook or the taxpayers would be liable or not. There is specific language in there that protects the local governments from any kind of liability on that, and that only the tax increment is pledged, nothing else. In other words, it's not backed by the good faith taxing authority of the local jurisdiction.
Is that going? And I'm gonna pass this off and let some other people ask questions. But is that going on right now with Atlantic Station and the AIG bond package that was initially put forth on that, and the scope of the other projects that are being done there? Therefore, basically reducing the overall market value of the entire development. Is that going on currently?
Can you?
There is some negotiations going on. I don't know the details of it, but there is some negotiations about, and I'm not sure whether it's refinancing the bonds or what's going on, but there is something going on there.
A lot of times these bonds are priced so conservatively, what they find out is that there is quite a bit of inflationary value increase in the property over that period of time. So they can refinance it many times for a shorter duration for a lower rate. I don't know the specifics of Atlantic Station. Most of that project's been built out. Yes, they are still building on it, but a lot of it has been completed.
My question is, y'all have been referring and comparing to DRIs. What is DRI?
A DRI is an acronym for Development of Regional Impact, and it's a state law that requires any development that is of a significant enough size that will have an impact on traffic and other public infrastructure that could go beyond the scope of one jurisdiction, a county or a city. They require the Regional Development Authority, in your case, Atlanta Regional Commission, to come in and to study that project. And basically they come back with a recommendation. They say, based on what's being proposed, here's the impact that we feel like it'll have on your infrastructure, and they can either say there's enough in this project to address that burden, or they can say there's not enough, and they could say that, look, this road really needs to be 4-laned, or this you're going to have to do this and this to accommodate that. And then the local officials can then take that information and go back to the developer and say, look, if you want the approval for the project, you're going to have to put in turn lanes here or intersection improvements down the road, that kind of thing.
Just as a point of clarification, on the TADs, the bonding organization, whoever actually goes and pulls the bonds, they're still responsible for both that base level, the base level tax amount as well as that incremental amount, and they pay that incremental amount directly to the bonding company. Is that how it works?
Well, it's the property owners that are obviously paying these property taxes, and the portion of the property taxes that are the tax increment, instead of going to local governments, they're going to pay back the bondholders. And so it's whoever owns that property, whether that property is owned by a private individual, a company, a developer, a bank, whoever owns the property is responsible for paying it.
And again, the bonds are used for the initial infrastructure improvements to begin with.
That's right. The bonds, yeah, they borrow the money to bring this property up to a standard where it could be developed, and then once it's developed, they're paying off the investors with those funds.
A couple of comments. I'm Bob White with the Henry County Development Authority. We're the local economic development agency in Henry County, and at our most recent board meeting, our board did adopt a resolution in support of the constitutional amendments. A couple of key things that I'd like to reinforce that Sonia had said about TADs in general, and as you've said, Clint. It's Clint?
Yes.
Okay. Tax increment financing has been used in other states for years. Georgia's been one of the slowest states to come around to using TADs. And the key with tax allocation districts or TIF financing is you take a property that would otherwise has, like she says, constraints. There may be environmental issues, as was the case with Atlantic Station, which was a former closed steel mill. Very significant cleanup cost. I can also envision sites that have a lot of water on them, have wetland mitigation, that it's not worth a developer's time and expense to go and do those without some type of inducement to come in there and to do that. And by using the TADs, it's developing a piece of property that would not otherwise be raised. And I think another key element for us here is, and you alluded to it, both of you in there, there's not a requirement that the governments have to engage in this. The three typical groups that come together, the counties, the cities, or the school board, don't have to do this, and they could come up with a mutually agreed upon agreement that that does address those issues. I think Representative Davis makes some excellent points about those types of developments that have significant residential development. You alluded to one, the project was going to be significantly different than a lot of those others that are commercial type developments that are going to create, in the case of Atlantic Station, sales tax revenue, create jobs in the case of Atlantic Station, office jobs, and those to go along with the retail jobs that are being created as well. So it's a tool to do this. There's no requirement that local governments have to enter into these agreements. Without the enabling legislation, we don't have the ability to do that. We don't have the ability as a local government and local community to look at adding those particular elements in it. I too share the concern that Representative Davis has about the cost of education. We know that, as you said, half or more of the property tax revenues go to our school system. Our school system has been growing at an unbelievable rate because of our tremendous population growth. So anything that we do that takes away from our ability to be able to fund the operation of the schools, only a relatively small percentage of that goes to debt service. A bigger chunk of the property taxes goes to the operations of the school system, the salaries, the staff, the employees, and I think that's one of the points that Representative Davis has made. But I think the point you made, you can negotiate in pilot agreements, and it might not meet with a lot of favor with Steve Cash in talking about this, but the one area in Georgia that impact fees cannot be utilized for is school development. And I would suggest that the legislature, that's an appropriate topic for y'all to take up and look at that. Why are we not able to, in fast-growing areas, utilize impact fees for the thing that's impacted the most, which is the school system? That's a separate issue, and I don't want to detract from the discussions here. But the bottom line is this is just a tool that allows us as a community the option of determining whether or not we want to do this. Without the ability to do it, it does cut the school system revenues out of the equation on that. So it's just a tool. If we don't have it, we can't do it. If we do have the tool, it doesn't mean it's going to be done. If that's not. One final comment, Clint, on DRIs, and in your question about DRIs, the Atlanta Regional Commission, you're correct in that the regional planning agencies don't have any teeth in DRIs. In the Atlanta region, however, we do have teeth that comes in the form of the Georgia the Regional Transportation Authority, which can withhold transportation funding from communities that choose to override their recommendations. So that is something that we have to look at. And there is a concern with going with projects, for example, South Point here with the DRI project, that ARC kicked it back because there wasn't a housing element attached to that, even though there was a lot of housing within the immediate area in there. So that's, again, that's a sidebar issue. That's something we need to deal at through the ARC and through those other regions. But the Development Authority views this as being a tool in our toolkit for our ability to be able to do that, and that's the reason we support it.
I'd like to also add to what you said. You mentioned the authority of the school board, city council, and county commissioners to decide whether to contribute and be a part of a TAD financing project. But whether this constitutional amendment passes or not, there's actually a couple other hurdles before you even get to the point where the local officials can make that decision. Your legislators, your local delegation has to, at the General Assembly, pass a resolution calling for a local referendum, and that has to pass so your citizens get the opportunity to vote throughout Henry County on the Redevelopment Powers Act. And only if the citizens pass that is this tool even available to your local officials.
I appreciate you pointing that out. There is additional hurdles even if the amendment does pass. One of the questions, he brought up a lot of the educational sides. I didn't really get into that side of it today as much as I have in the past with conversations with Mr. White and myself. But my question is going to be for the school board members themselves. And now obviously these persons are elected to educate our children in best practices and deal with the school budgets there. What kind of training or is your organization going to utilize to help with the school board that are going to have to make decisions that are going to be on, according to Atlantic Station, a $1 billion project, estimating or speculating what the value of a piece of property is going to be in 25 years from now? when their number one goal is to educate children. And that was a big concern of mine. I brought that up in the debate as well. And I just want to know, if this amendment does pass, is there a commitment from the ACCG to go out and help educate the school board members? Because, I mean, it's going to distract from their attention to what they really should be doing. And these are big, complicated, I mean, the amendment's complicated enough. Can you imagine them looking at a $1 billion redevelopment plan that's 30 pages long and talking about all the different housing and commercial bases and what's going to happen in the different phases? So I just want to know if there's going to be training for them available through your organization or others, and if, as this amendment will refer back to code section, there'll be certain requirements for them to obtain training as well, and kind of discuss that, and a commitment that we're not going to limit what they can and can't do when they're trying to make their own decisions.
The training issue actually came up a couple years ago in the General Assembly. If you remember, Senator Doug Stoner had legislation. It actually passed both the Senate and the House, and it was vetoed. But it would have mandated training. Right now, the training is voluntary. The training is available through the Carl Vinson Institute of Government, which is part of the University of Georgia, and it's done usually at least once a year. But it is voluntary. The school board members have to sign up and voluntarily go to it. What the legislation that was vetoed would have done is basically said anybody that makes a decision on one of these TADs must have first gone through this training. We supported that, and so did the Georgia Municipal Association, and I'm sure that we would support it again if it moves to the General Assembly. There's one component to this constitutional amendment that hasn't been mentioned. If this constitutional amendment passes, there's a clause in there that before the schools can start increasing or using their tax increment again, the General Assembly has to enact some state law. And that was done specifically because Representative Earhart, who is up in the Cobb County area where Marietta's had, this has been controversial in the city of Marietta, he placed that in there so that the General Assembly then, if this constitutional amendment passes, would have the opportunity to go back and address some of those issues. My guess is that that would be the period of time where they would look at the training issue. So before the school boards can even use this, if the constitutional amendment passes, the General Assembly will get to go back into the statute and put some things in there to maybe strengthen and address some of the concerns that you've raised.
Yeah, and I also just want to mention, and you're right, school boards, they're in the business of educating children, not doing economic development. In the case of Atlanta Public Schools, we do have one school board member who sits on the Atlanta Development Authority's board. And then we also just recently, a few weeks ago, did a bus tour with a lot of the members of Atlanta Public Schools, their board and their senior staff, to drive them around the TADs and actually explain to them how things work. And they'll often hire consultants because they're not in the economic development business, and there is a lot of cost-benefit analysis that goes on. They'll hire consultants that will make recommendations to them whether they should participate in TADs or not.